Hello, it's Phillip Taylor from Richmond Green Chambers speaking. I've got a book review here which is about the Human Rights Act. Oh no, you think, not again, more Human Rights Act stuff. Well, this is a slight difference to the normal book. This is the actual book itself, and there's a picture of the cover on Flickr. It's called Human Rights, Judicial Protection in the United Kingdom. And it's a very important book because we're really looking at the sort of judicial review of human rights, if you like. It's written by Sir Jack Beatson, who's now a High Court judge. Obviously many people know him as a professor of law. And it's got in addition a distinguished group of 4 people: Stephen Gross, Tom Hickman, Rabinder Singh, who many people will know, and Stephanie Palmer. The book's actually published by Sweet and Maxwell. It's a big heavy book, and you can see from it it's got again the standard layout with paragraph numbers, which Sweet and Maxwell are very happy to have. It's basically about 800 pages long. Huge number of cases at the front, which is to be expected with judicial review, and it runs through very nicely all the main aspects of the Human Rights Act and the judicial activity that we've had so far after 10 years. I'll leave the book there and you can have a good idea of it. Now what I've done is I've produced a number of reviews. It's obviously been out a little while now, and I'm going to try and get some of the reviews in some journals, but it will be very widely available on the internet, Amazon and all the usual sites. The title I've given it is taken from Lord Bingham's remarks made in the front of the book. I've called the title The Human Rights Act, A Buzzard's Eye View, lifting it directly from Tom Bingham, because as he remarks in the foreword, this is judicial protection as a manual, in my view, on the Human Rights Act, and therefore it is what he says as a buzzard's eye view of the existing legal landscape in the United Kingdom following the ushering in on the 2nd of October 2000 of the 1998 Act. Now if we take the metaphor further, the 4 authors, including the 5th author, Professor Sir Jack Beatson, they actually soar above the landscape, noting the contours of existing case law, and while at the same time they do retain in this book an acute sensitivity to the detail of what is taking place on the ground. So you can see the picture flying above, and on the ground you're watching what's actually happening to the landscape. And we then go on with a further quote: "A new day and a new legal culture." Actually, this is exactly what's been initiated, and Lord Bingham notes it cannot be gainsaid that rights already existing have been immeasurably strengthened, adding that after 8 years or so, it's now time to take stock of the HRA. That is actually what Jack Straw has done during the latter part of 2008. And obviously he's the guy who introduced the Act and now is the Lord Chancellor, so it's been a useful time to review where we are. So what we've got here from Sweet and Maxwell is the first comprehensive account of the ways in which human rights are protected in the domestic laws of the United Kingdom. Obviously, as we all know, the Human Rights Act affects everything that we do within the legal world. The personal, temporal and geographical scope of the Act is fully examined in this book in a lot of detail, and that, as to be expected from Sweet and Maxwell. And in the preface, the book, they indicate, consists almost entirely of new material. So I think it's right up at the top end of the contemporary information that we have about the working of the Act so far, as far as the judiciary are concerned. What the book does is it amply fulfills the need for a thorough and definitive work that concentrates on the constitutional status and the operation in practice of human rights at common law, We've obviously signed up to the convention, and obviously we were signatories to the UN convention 50 years ago. But under the new Act and under the 3 devolution statutes, we're obviously moving forward. And it's in discussion of general principles such as the concept of proportionality, or reasonableness as I actually call it, the weight, the deference and the remedies, which we need to sort of weigh up. And the book introduces material not covered in such detail, as far as I understand it, in any other major human rights title. So that really is its USP. Focusing on the interaction between the Act and existing statutory and common law remedies, and of course the case law from the European Court of Human Rights, and also obviously covered by Articles 41 and 46, the work assesses the impact of human rights law on the decisions of public officials in particular, and gives a detailed account of the protection of human rights under the devolution statutes that we have for Scotland, Northern Ireland and Wales. Just at a glance at the massive tables which you saw right at the beginning, actually over 130 pages long, that includes of course the cases, the statutes, the statutory instruments, treaties, conventions, so on. It convinces people that the impact of the Human Rights Act in the laws of the United Kingdom is now firmly embedded, and there's a huge amount of information currently available. Obviously, as many will know who may be reading this book or seeing this review, it is a subject which is a popular topic and a popular course at many universities. It's therefore thought-provoking to note a crucial point made by the authors that, quote, "It's important to recall that many of the rights that are to be found in modern declarations of rights were long ago protected by the common law." Exactly so. You remember the arguments why the Tories didn't implement this sort of thing is that Margaret Thatcher, for instance, and many others said, well, we've already got it. Why do we need to have this? And of course, critics like myself have tended to take her line to a certain extent. However, we have the Act. And as a result of that, when we look at things like the tort of false imprisonment, the writ of habeas corpus, long cherished rights concerning the common law of freedom of speech and so forth, obviously the issues are still there, and we do have the bigger single issue of the relationship between the freedom of expression and privacy. That one is going to run and run. I think it's important to note, of course, that the authors assert clearly that the Act lays down a floor and not a ceiling for the protection of human rights in domestic law. So, as Lord Bingham concludes, so do I by agreeing with him and saying this book will be a boon to both scholars and practitioners, and a major contribution to the literature on human rights. I'll end with one other point, and that is that how right he is, and I'd love a shorter version for my learners, because I think what we've got here is excellent for those people who are reading for a degree. Thank you very much. Bye-bye.